Hi everyone. We are talking about legal and accounting issues for your business. Today, of course, is about entrepreneurship and how we can ensure that you have a proper legal and accounting structure set up. So let's begin by discussing the attorney. Of course, you want your attorney to have the right experience, have a good understanding and rapport with you, be affordable, and have great references. So how do you ensure that happens? First of all, you want to ask the questions of, does your attorney take on small clients, and will he or she really understand your business? It's important to develop a rapport to make sure you feel comfortable talking to this person. Now, one thing that has to be mindful and you got to be careful about is the cost of an attorney's fee. I don't know many attorneys in this range. I know a lot of them in between this range, between $100 and $1,000 per hour. Now, you also want to make sure you get references to understand what clients have they served before and what are their particular expertise. In addition to that, ask a lot of questions, and if you can, put these questions in writing. You want to ask if they can estimate how long it will take for you to get information such as printing or photocopies, or how long and how do phone calls work, because they do charge you for those as well. You want to learn how the increments of time is used to calculate your bill, because you will receive one. You want to also request monthly itemized bills to ensure there's prompt payment on your end to the attorney, and try if you can to establish some sort of regular meeting so that they are fully aware that you are vested in your business and you're vested in the conversation and the relationship with them. Now, if we move into the structure of how an attorney bills for services, this is where it gets a little bit difficult. You have to ask the question of, are they on an hourly or per diem basis, or does it include travel? Is it a flat fee or the monthly retainer fee? Is it a contingency fee? So all these aspects are important aspects to understand the structures of how attorneys bill for their services, but you want to ensure you get all these agreements in writing. Do not assume that this will come later in the process. It's important to establish it up front and get information about how attorney bills their services, because it's very different from attorney to attorney. When you're hiring an accountant or a CPA, some similar things occur. Of course, there's different management consultants or estate planning, depending on what kind of business you have. There again, you want to ensure you can get along with this person, have a genuine concern and a trust built up between the two of you all. Now, the fees may not be as expensive, but of course that can always change as well. And don't forget to ask references. Who have they done business with before? Who can say things about them, about how their experience was, to help you make a really good, solid decision? Those are really important components. Now, as you're hiring an accountant, there are 4 basic areas of expertise. Certainly, there are the ones you understand and you heard about that we've talking about for business services, accounting and record keeping, and you may also hear this called bookkeeping, tax advice or tax planning, and then auditing. These are different types of expertise that you would find in a typical accounting firm, but that could always change depending on what your needs are at various levels of your business. Now, here's some information that's a little bit unique. The offer. Requirement of an offer. For an offer to exist, there are some criteria to be met. And you would assume this is in a situation where if you have already got your attorney lined up, you have your accountant lined up, now you need to proceed and get some business. And so this is information regarding your business. An offer may be terminated by revocation, rejection, or a lapse of time. That can be based on how the business is set up. Oops, let me go back one. And then there's other information about the fact of the acceptance of the offer in particular. Now, this could be an offer of the service that you're asking for or the services that you're providing in your particular business. Consideration is a second major requirement for a contract. There's typically a period of when you provide someone a contract or a proposal, there's this time involved. And so that's a consideration period that typically is involved when you're trying to get someone else to agree to a particular service or a product or some sort of deal that you're presenting to them or they're presenting to you. Information about contractual capacity. Individuals who are parties to agreement must be able to contract. So let me repeat that once again because I said it a little bit fast. Individuals who are parties to the agreement must be able to contract. In other words, things like these three key criteria can make a difference in the contract. Is the person that you're making a contract with a minor? Do they have some sort of mental capacities that you're not aware of? Or potentially, are they intoxicated? Those things could blur their reasoning, or at least make your contract null and void, depending on these particular situations. There's another concept called legality or reality of consent. A contract must have legality of purpose. It must be consented to, of course, so there's no fraud. And a contract may be oral, so certainly we want written contracts, but oral contracts are also enforced in various areas as well in various states. Now, another area that you've probably heard about is this area of breach of contract. Now, breach of contract occurs when one party fails to perform according to the terms of the agreement. The other party can then bring a lawsuit for breach of contract. This sometimes occurs in small claims court, for example, or when there are damages that may be monetary based on a particular performance that did or did not happen. Now, let's talk about product liability. Most states allow any person in the chain of distribution to be sued for breach of warranty. So any person who suffers, for example, personal or property damage from a product that did not meet the expectations can potentially sue. And so there are so many lawsuits out there regarding this, but just give you an idea to watch out for this, because it may be something that you have to be thinking about if you're building a product or if you're building a service that doesn't meet expectation. Now, there's these two areas around relationships. An agency relationship is created between two parties when one party, the agent for example, agrees to represent you. The term fiduciary relationship is used to describe such a relationship because it's built on trust and confidence. So typically this happens, for example, in a sports agency, maybe is a good example of an agency relationship. Or if you were an attorney representing a client, those sort of relationships can fall up under this discipline as well. Patents. Patents, you've heard about these, but what does it really mean? Well, the federal government issues a patent to an inventor for developing a product or even a process. Now, of course, some of this information is a little bit dated, but it gives you an idea that if you're trying to develop some sort of prototype or some sort of new process, you can get protection. A patent contains two parts: a disclosure statement describing the invention, and a set of claims which covers the invention as well. So this is a really critical area if you want to protect your ideas and protect your investment going forward. It's important to consider how patents play into protecting you as an entrepreneur. Trademark. A trademark is a word, a name, a symbol. You've seen it, the little R, of course, within a circle, or a T for trademark. You can do all sorts of trademarks on packaging or on labeling, and even a combination of color. Take, for example, when the Coke company has their logo, it is a red, and so it's a particular Coca-Cola red. Or if locations that you see around different branding icons have particular logos, they have typically trademarked those logos. So, for example, it could be the Chick-fil-A sign and the cows. All those are more than likely trademarked for that company, and I'm really 100% sure that's the case. Copyright. Copyrights, therefore, again protect you as well. So sometimes we use copyrights and trademarks interchangeably, but it gives you some information here on this slide about one can claim a copyright simply by using the notice of copyright on written work. There again, it's important to see what the new laws are and see how it plays into your particular situation, because they continually change and are updated. Bankruptcy. Something nobody wants, but unfortunately it happens. The term bankrupt refers to a situation where a person just simply is unable to pay their debts as they become due. So there are two types of bankruptcies, and the big picture is that you hear these numbers, Chapter 7, Chapter 11. Well, both of these are different types of bankruptcy that people have had to use in the case of trying to salvage your business or try to start something new, or just say, hey, I need a fresh start. Now, of course, there are major complications and major ramifications for doing so. So this is something that most businesses and business owners don't take lightly. They really want to make sure that they're having a very calculated decision about, is this the right time or the right move for them? It's something that is an option that's out there. Chapter 7 and Chapter 11 are different forms of bankruptcy. Voluntary bankruptcy takes place when the debtor files a petition of bankruptcy in federal court. So this is bad. And so when the debtor petitions the court for bankruptcy protection, you have to consider your liabilities and your assets for your company. So this is something that is just out there as another way to consider how bankruptcy can be very detrimental to your business. Another one, involuntary bankruptcy, occurs when a creditor files a petition. There again, these are just two ways to think about bankruptcy. In addition to the Chapter 7 and Chapter 11, there's different types. And that concludes our presentation regarding the information on accountants and legal aspects of your business. Now, we certainly want to make sure that we are conscientious and careful about the things we do in this area, because it's very, very important to get it right the first time. So we will talk more about this just in our conversations with our entrepreneurs and just really understand how they look at legal and accounting. Thank you so much, and I'll chat with you soon.